Hi, good morning, everybody. Very warm welcome to this morning's construction and engineering webinar brought to you by Birketts. Thanks very much for joining us for our spring update. My name is Stefan Harris-Wright. I'm a partner in the construction and engineering team at Birketts. So I'm joined this morning by several colleagues from the construction engineering team. I've got with me George Elliman, Patrick Cooney, and Steven Williams. So hopefully you've heard of Birketts before, but just in case you haven't, there's a bit of information for you at a glance up on this slide. I won't spend too long on this, but just in summary, we're a full service top 50 UK law firm. We've got 7 offices across the UK in the east of England, London, Kent and Bristol. And as part of our overall firm, we've got a specialist construction and engineering team who deal with both transactional, non-contentious and also dispute contentious related construction matters. So in terms of what we're going to be covering in this morning's session, George is going to talk about a hot topic in construction, which is sort of sustainability type angle around reuse of materials in construction projects and highlighting some of the risks, liabilities and best practice in that area. Patrick is going to give a bit of a review of 2024. Last year was a busy year in the construction legal sphere, so Patrick's cherry-picked some of the highlights and key issues from last year, and we'll summarise those. And then we'll finish off with our traditional sort of final slot, which is an update in this instance from Steven Williams on some recent interesting construction and engineering cases. Before we get into the sort of meat of the session, I've got a sort of handful of housekeeping items just to kind of run through. There's an opportunity for delegates to put their questions to our panel. We're going to have time for a bit of a Q&A at the end. So if you have any burning questions, please don't be shy. Come forward and send those through to me. They come through anonymously, and we will do our best to get through as many of the questions as we can in the time available. I'm going to draw proceedings to a close promptly by 1:30. And just finally, before I hand over, the session is being recorded and you'll get a link, hopefully in the early part of, well, by the early part of next week, with a link to the recording of the session and also a copy of the slides. So without further ado, I will hand over to George for the first main section.
Thank you, Stefan, and thanks everyone for joining us today. So we decided to do this now about reuse of materials because it's topical. It's something that's really changing quite dramatically in the construction industry, certainly compared to sort of 10, 15 years ago. We're seeing way more of these types of projects coming into tender, come to completion, sort of driving the net zero agenda in the UK, and taking a bit of a step back, looking at the status quo of contracting, building contracts, design liabilities, that kind of thing is important at this stage. So a bit of initial background, which I'm sure a lot of you are already aware of. Built environment is a huge part of the carbon output of this country. You have that split into sort of embodied carbon, which is essentially the carbon that you expend when you're building a project, when you're procuring the materials for your project. Then you have your operational carbon, which is more, what is the carbon that we use in the process of using this building until the end of its life? So the other side of that is, what do we do with buildings when they reach that end of life point? How do we deconstruct those buildings as opposed to a more conventional demolition? And how do we make sure that any materials that still have utility can still be used, even if the building that they are found in perhaps doesn't? So that's the landscape within which a lot of construction in the UK is starting to move in that direction. If you look at things like the construction playbook, that's putting a lot of emphasis on reuse of materials. Ditto, client needs are increasingly framed around things like BREEAM, net zero building standards, guidance documents like the BCO Office Guide for Fit Out now expressly refers to reuse of materials, passporting of materials for traceability, making sure they can then be used onwards into future projects. And that involves a little bit of additional risk when we're talking about reused materials. They tend to come with less secure warranties or guarantees, a little bit more uncertainty about their future design life, their future performance. You're also going to have some issues with traceability, some issues with insurance. So taking a step back, looking at how does this relate to the current contracting model. So a very quick run through of what the implied design liabilities and materials liabilities would be. So these will apply where there is no alternative drafting in a building contract that sets out an alternative higher or lower standard. First, you have this designer standard of care of using reasonable skill and care. And then where design responsibility is being taken on, there is an assumption that the product of that design is going to be reasonably fit for the agreed or known purpose. And materials are to be of good and proper quality. Of those three, as I'm sure many of you know, fitness for purpose is considered the most onerous of the three. It's more of an absolute standard. If you think about the general design standard of care, there's an element of interpretation within that, so that if something does go wrong, you can still frame an argument around, yes, this happened, but we did still exercise skill and care. With performance specifications and with fitness for purpose, if that event happens, there is less of a room within that to make a case of skill and care being used. And then translating those factors into the standard form building contracts, JCT Design and Build 2024 has clause 2.1.1, which is around the contractor completing the design of a building using the kinds and standards of materials, goods, and workmanship. 2.1.5 is a new but not really new clause in the JCT. This is something that was previously in the supplemental conditions, but has been brought in 2024 into the main body of the contract, and this goes to environmental performance and sustainability. And then at 2.17, you have these design-focused clauses around using reasonable skill and care in the design produced. 2.17.1.2 is an exclusion of the fitness for purpose implied standard that I referred to in the last slide. So this is a very common amendment that you will see requested. The JCT does it by standard, and this goes to the fact that fitness for purpose is considered onerous, often uninsurable, and a major problem. But standard form contracts, as we know, are very regularly amended. So you'll frequently see widening of that standard of care. You'll frequently see the fitness for purpose exclusion taken out, meaning that this could possibly apply by omission, i.e. if we don't mention the fitness for purpose, then the implied term can apply. And you'll also frequently see a transfer of the full responsibility for design, including any employer's requirements, over to the contractor. And then finally, around materials, you'll frequently see, although less so nowadays, more stringent requirements for those materials to be better than satisfactory, good, more towards new, and more towards specific performance specifications set out in the contract documents. So a really good case to look at when we're thinking about designs, specifications, and that interplay between fitness for purpose, performance specifications, and design liabilities is the MT Højgaard case from a few years ago. This was in the Supreme Court. This is a case that's related to an offshore wind farm, and it's a really good example of when a fitness for purpose obligation or a fixed performance standard can run headlong into design standards of care. So in this case, MT Højgaard was contracted to construct and design the wind farms, and they were required in the specification to meet a prescribed design, which is something called J101, but also required to meet the criteria for a design lifetime of 20 years without planned replacement. Now, without going into the detail of exactly why that wasn't possible, it went to a technical issue with the calculation of that J101 design that meant that the structural loads weren't correct for these structures. These two specifications were incompatible, and the wind farms eventually failed quite quickly after their construction. So the case was around who was responsible for those rectification costs. And the Supreme Court found that instead of inconsistency releasing MT Højgaard from liability, the correct analysis was that the more demanding of the two requirements had to prevail, as the less rigorous could be treated as a minimum requirement. And this extract here is a real key part of that judgment. They held that MTH would be liable for the failure to comply with the required criteria, as it was MTH's duty to identify the need to improve the design accordingly. So where they have this fitness for purpose or this fixed performance specification, this design life, where that is inconsistent with a lesser standard, it is up to the contractor, is up to MTH in this case, to adapt accordingly to meet that design life. And the reason why we're talking about this MT Højgaard case is because it's quite a good example to think about if we imagine a situation where an employer's specification leans quite heavily into certification for environmental performance, a certain amount of materials needing to be used from reclaimed or reused sources, as well as also having performance specifications or design life clauses within there. How do we navigate that potential conflict between the inherent uncertainty around the long-term design life of a reused material with a potential fitness for purpose obligation? So in this worked example, you'll see I've brought these into it. The certification for environmental performance, maybe that's BREEAM, maybe that's something else. They may need to procure certain amounts of steels or cement from reclaimed sources, perhaps the glass. And then let's say a design life of 50 years attached to that building. Now, if that contract doesn't exclude the designer's implied fitness for purpose obligation, then there is an elevated risk to the designer or the design and build contractor here because of not adequately reflecting the fact that reused materials have, and it's on a case-by-case basis. Sometimes you'll use reclaimed materials which have a really solid traceability, really solid surveying record. They've been checked. You're fairly confident that these are going to perform as well as, or close to as well as, a new material. Sometimes you're not going to have that certainty, and it's in there where we have this risk to the designer. So let's say there is a broad fitness for purpose standard across the entire project, but a certain part of this, some structural steels, going to be reused, perhaps the electrical lighting system is going to be reused from a previous building. How do you then meet that if something goes wrong and you fall on the wrong side of a absolute obligation? I've just brought back in that key quote from the Højgaard case here. It was MTH's duty to identify the need to improve on the design accordingly. So some key takeaways from this. First of all, think about template contracts or template contracts you're provided with by clients. Some of these documents can stay fairly static. They may include drafting that would have been commonplace and uncontroversial, say 5-6 years ago. Let's say a clause requiring materials to be new as well as satisfactory quality. is that going to still be appropriate for this project? If we're going to be using recycled materials, are those kinds of bespoke clauses, definitions, standard form amendments still going to be applicable here? Other point I'd make is around clear and consistent specification. So part of the reason the Højgaard case comes about is because the specification there was inconsistent. And although it ultimately fell to Højgaard to cover the cost of rectification, both parties, I'm sure, would have preferred that specification to be absolutely clear and unlikely to result in this kind of defect and then liability. Saves an awful lot of money in taking a case to the Supreme Court and the rectification costs and the out of service period for those defective wind farms. And tied to that is the link between those technical contract documents and the contract itself. So if we're going to include something like a strict performance obligation in the specification, or meeting J101 in the case of Højgaard, is the drafting of the contract appropriate for that kind of project? Is there any room within there to potentially carve out certain parts of the design that's being reused, carve that out, maybe apply a separate standard to it, maybe consider some form of risk sharing, a different allocation of risk, if you do eventually end with a defect? And with that, I will pass over to my colleague Patrick.
Thank you, George. I'm going to be having a look back at some of the key developments arising in 2024. Briefly on the Building Safety Act, it's been coming into force at various stages since the Act came in late 2022. Now, this is not meant to be in any way a detailed look at the BSA, but we couldn't have a look back without mentioning the BSA in some detail. So I just wanted to have a very brief recap on some core principles. So what came in? We've seen the duty holder regime come in. So responsibilities on all of those who commission work and who are involved in the design and construction process, legal responsibilities under that new regime. And the competency requirements also fit into that regime. Anyone doing building work or design must be competent and demonstrate their competence. That how that is done is a whole nother subject, and probably there's a subject to an entire webinar on its own. And demonstrate their ability and competence to do the work in a way which complies with the building regulations. The building safety regulator is a key element of this whole regime. The sort of overseeing regulator. It's a function of the HSE, and the regulator oversees the safety and performance of all buildings, advises on emerging risks, possible changes to legislation, and fundamentally enforces breaches of the Building Safety Act, which can include criminal prosecutions. Excuse me. The HRB regime, there was particular focus on higher risk buildings, and that is buildings which are at least 18 meters high or 7 stories high with 2 residential units, and any care home or hospital. So the HRB regime is of particular importance because many of the detailed requirements under the Building Safety Act, many of the more onerous provisions relate specifically to HRBs. And you'll have seen the mention of the golden thread. That all ties into the HRB regime, and that's the duty to maintain information and update information, core information about a building's design and construction, which could be shared, knowing that it's accurate and up to date. The gateway regime also falls into the HRB process. Gateways at which points duty holders must be able to demonstrate compliance with the BSA before moving on to the next stage of the building control process. And of particular relevance to 2024 is building liability orders, because we've seen the first case of the High Court using its ability to issue these orders. So no longer can a developer hide behind an SPV or a shell company to avoid liability for safety defects. You can't run the argument that the company's got no assets, so if you come after us, we'll just go bust, because the court can look behind that now, look into the wider corporate structure and issue a liability order, not necessarily against or not against the company that entered into the contract that has no money, but against an associated or connected company. Obvious example would be the parent of a group where just a shell company with no assets has been used as the contracting vehicle when all the money sits with the parent. If it's just an equitable to do so, then the court can make an order that the parent in that situation pays. Moving on now to JCT. Now, we did an entire seminar on this, but just to do some very brief recap on some of the key provisions of the new suite, which came out late last year. So there's a new Article 3. It's got a real NEC feel, this. An obligation on both parties to cooperate, collaborate, and work with each other in good faith and in a spirit of trust and respect. So a very sort of NEC worded clause, and the NEC might say that JCT is a bit late to the party on that one. George mentioned the sustainability and environmental impact clauses, which aren't actually new. They've just been brought up from the supplemental conditions. There's very little about the BSA in the new contracts. I mean, generally the changes to the 2024 contracts are iterative. They're not, they're not groundbreaking. In terms of the BSA, the principal contractor and designer are named in the contract particulars and identified there. There's an employer obligation to provide information to the contractor about the building. But really, there's very little that's Building Safety Act specific. There's nothing for high-risk buildings. So if you're dealing with a high-risk building, you'd need to consider a bespoke set of amendments to deal with that much more onerous set of requirements. JCT's just dodged that one rather. And then George mentioned before, there's a response to the Hogard case in the JCT. So there's now a new clause which specifies that skill and care is the relevant design threshold, and a contractor is not to be held to fit for purpose for design. That's a specific response to that case. Okay, moving on to the second slide on JCT. A few other points to mention briefly. Epidemics are now relevant events. That was rather uncertain during the COVID period, but that's now been changed. And the existing relevant event around change of law, so you can claim more time if there's a change of law after the contract's entered into. That now covers the publication of guidance as well as changes in law, because what kept us all at home during COVID wasn't actually a change in law, it was government guidance, so not a specific law. So that sort of little hole has been filled. Those two things are relevant matters, but only if you stipulate them in the contract particulars as being so. So the default position is that those two things are cost neutral. Another change to respond to case law. Specific provision that LADs cease to accrue if the contract is terminated. after termination, you can still claim damages for lateness, but it's no longer LADs, it's general damages. In other words, damages that you need to prove, and that's a response to the triple point case. Another particularly significant development from 2024 was the publication of the government's final report on Grenfell. Now, on that slide there, I've listed some of the recommendations that came out of the report. Just to recap, the phase 1 report came out in 2019, and that was all about what happened on the night of the fire itself. And then the final report, or the phase 2 report, came out in September of last year, and that's the report that looked into the wider circumstances and the causes. 1,700 pages long, 58 recommendations, and some quite damning industry criticism. I've put some of the key recommendations on the slide there. So the intention is to have a single regulator for the industry, so much more than just a building safety regulator, but a regulator for the entire industry, whose role is to report to the government on changes required to legislation, how products should be certified, and potentially the licensing of contractors to work on higher risk buildings. It's also been recommended that there are minimum statutory requirements for building control approval, and that would include specific statements from the principal designer and the principal contractor that all reasonable measures have been taken to ensure that the building complies with all relevant fire safety requirements. A recommendation that there'll be a professional body for fire engineers with specific regulation on conduct and skills, which doesn't exist at the moment as it does for other bodies, for architects, for example. New testing methods for assessing products and how they conform with relevant regulations, and a whole update of all the approved documents that go with the building regulations, with input from academics and those with practical industry experience. Now, on the next slide, I've just listed out some of the findings from the final phase 2 report. Some pretty strong criticism of the government and the supply chain that was involved. It was said that government departments were complacent, defensive and dismissive in terms of their attitude to fire safety measures. The architect was particularly in the spotlight. It was said that the architect should bear a very significant degree of responsibility for failing to recognise the dangers of installing combustible cladding. In terms of the suppliers of products, there was particular dishonesty from the supplier of the cladding panels. On learning that the panels wouldn't meet relevant fire safety standards, the head of the technical sales team wrote in an internal email to the organisation, "We have to keep this very confidential," and then subsequently deliberately manipulated test data, which was not picked up by certifying bodies, so they just accepted tests as presented without scrutinising whether they'd been carried out properly or without scrutinising the underlying data. So all of those failures and dishonesty was compounded. The contractor used an inexperienced team and didn't ensure that the supply chain they were using was competent, and the building control surveyor was overworked and had limited understanding of the panels used. So some pretty damning criticism of the supply chain on that project. Okay, I wanted to say a few words about insolvency. Cheery topic for the middle part of the day. On the next slide, I've just mentioned a few points about what's probably the most significant insolvency of last year was the ISG group, went into administration in 2024, multiple arms to that business, and the 6th largest construction firm in the UK with revenues of about 2.2 billion. And the government was a particular loser in this situation because they had about 1.6 billion invested in ISG. Actually, interestingly, including a £300 million contract that was awarded in January last year for a new prison, when the reports were already circulating about ISG's problems, but the contract was awarded nonetheless. What can you do to protect against insolvency? Well, that you can't stop it, but there are certain due diligence you can do to better protect yourself, to ensure yourself. And obviously you can do the financial due diligence before engaging anybody, company's house information, accounts and so on, credit checks. It's worth bearing in mind that company's house information is only accurate as at the day it's submitted, and it only needs to be submitted once a year in terms of the annual account. So it's only really a snapshot on that particular day. So, you know, much after that time, it's going to be out of date information. We're seeing quite a lot of increased demand for parent company guarantees and performance bonds. Obviously, disadvantage with performance bonds from a client's perspective is that they're expensive and becoming increasingly expensive. So on some projects, we're seeing increased retentions as a sort of client protection instead of a bond. I've mentioned avoiding wrongful termination on the slide there. Need to be careful in an insolvency situation, which will often trigger a right to terminate a contract, that you don't terminate too soon. Usually it won't be enough under the contract for the other party to be in trouble financially, late paying. It won't normally trigger a termination right unless the insolvency process has actually been commenced formally, for example, by an administrator being appointed. So just be careful that you don't pull the trigger too soon, because then you'll compound the problem and be on the wrong end of a wrongful termination claim. And then a practical point at the end is don't let large amounts of debt accrue. Maybe easier said than done. I understand commercial pressures don't bite the hand that feeds you, but there is a very rapid dispute resolution process available for construction contracts, and obviously the more that a debt accrues, the greater your risk becomes. Okay. Cases I'm going to mention very briefly because Stephen is doing a more detailed update on recent cases, and there are just two I wanted to mention very briefly from 2024. So on the slide there's a fair bit of detail, but all I'm going to mention about the Abbey Healthcare case is that it was finally determined that a collateral warranty is not a construction contract. What does that mean in practice? Well, it means there's not an implied right to adjudicate. So you can't adjudicate under a collateral warranty. That is unless, of course, you had a separate provision which incorporated adjudication. You could have a bespoke clause that incorporated adjudication contractually, but in terms of an implied statutory right, it won't be in a collateral warranty. And then lastly, again, there's a fair bit of detail about the Bellway Homes case there on the slide, but again, the key takeaway is that it's been determined that an adjudicator can hear a dispute that considers a smash and grab argument and a true value argument at the same time. The context to this is that only a single dispute can be referred to adjudication. So there was uncertainty about whether bringing your claim on a smash and grab basis and a true value basis would amount to two separate disputes, and therefore be outside of the adjudicator's jurisdiction. But you can bring them both at the same time. Practically speaking, that means you can bring the argument that the final account that the amount you've claimed is due because the pay less notice or payment notice hasn't been issued on time, and or at the same time you can bring the argument that even if that fails, the sum if claimed is due because the employers significantly undervalued the final account. But it's two arguments to get to the same answer effectively. So you can run both of those at the same time. Okay, that's all I wanted to cover as a quick recap of 2024, and I'll hand over to Stephen, who's going to talk about more recent cases.
Thank you very much, Patrick. That was a very interesting canter through 2024, and what a year it was. Pretty sobering, the look at insolvency, and I fear that's an issue that's following the sector into 2025. Let's hope the outlook looks a bit better in due course. But good afternoon rather to you all. I'm Steven Williams. I'm an associate in the construction engineering team here at Birketts, and I'm going to give you a bit of an update this afternoon on some recent case law that's impacting the sector. First and foremost, we'll look at the Darcliffe case, which is all about bringing a proper and full cause of action. It was brought in the context of a £7.5 million loss that was suffered following ground dissolution. We'll also be looking at the BDW and Ardmore case. This is a massive change in that it was decided that claims under the Defective Premises Act can be adjudicated. And lastly, we'll be looking at the Toppelson and Rolls-Royce decision, which is all about caps on liability and the court's interpretation of such clauses and whether or not interest can be claimed in addition or if they're included within the cap. So without further ado then, the case of Darcliffe. To give you context, Glanville were engaged to carry out a desktop report on the ground conditions of a site and the development of a site that they were looking to develop. Glanville subsequently produced a second report, which was substantially the same as the first report. And further to those two reports, Ground and Water Limited, GWL, were engaged to carry out a further intrusive investigation in 2017 and 2018. I should mention that Darcliffe settled their claim against GWL before it got to trial, so they somewhat fall out of the picture. So Darcliffe purchased the site following receipt of those reports, but then subsequently discovered that it was at high risk of ground dissolution due to the presence of chalk under the site. Now, this hadn't been flagged in any of the reports. It did say there was a low risk, but didn't elaborate any further. But in the event, of course, there was a very high risk of ground dissolution. So Darcliffe issued a claim against Glanville and GWL, that claim settled obviously, for damages of £7.5 million for losses it incurred following remedial works it needed to carry out as a result of the dissolution. In essence, Darcliffe argued a number of things. We wouldn't have bought the site had we have known about the risk of ground dissolution, and we would have taken a different view. So let's have a look on the next slide how the court approached this issue. Well, the judge found that there had been a clear breach of duty in that the report didn't include certain data and it didn't flag the risks. And in essence, the court found that the report essentially gave the site a clean bill of health from a geo-environmental perspective, which obviously transpired not to be the case. But looking at causation, so was the information in these reports, did that cause the loss that we're concerned with? Well, the court asked three questions. The first is, if Glanville were in breach, which of course they were, what was the minimum they had to do in order to not be in breach? The second question was that had the report not been in breach, not been compliant, would Darcliffe's corporate mind have been affected? So what would the impact have been? And thirdly, if it was so affected, would it have done so differently? And the corporate mind, of course, that's the directors. Had they have had a proper report, would they have acted any differently to what they did in practice? In relation to the first question, on the basis of the expert evidence, the court found that Glanville had failed to include certain details in the report, and there should at the very least have been a single line, warning of this possibility of ground dissolution, and it failed to do that. It failed to include things that any reasonably competent expert would have included. However, in respect of points 2 and 3, so the questions of would Darcliffe's directors have acted any differently, the court found that they were unconvinced that they would have acted any differently, and therefore the claim was dismissed. And essentially, this claim failed on causation. The court found that even if the report, was fully compliant, advised on the risks, it doesn't matter. That wasn't the cause of your loss. So what are the key takeaways here? Well, for developers, in cross-examination, one of the defendants mentioned that he only skim-read the reports. So really, he didn't really pay much mind to what was in the content. And bearing in mind that he didn't really take the content of the report, didn't really properly consider the content of the report, he cannot be said to have properly relied on it. So developers, don't skim-read your reports, review them in detail, and record any concerns that you have in writing if there are any risk points that are thrown up in the reports, and ask questions about the data, particularly in relation to any areas of concern. And also, don't take at face value who you've asked to do the report that they are competent. Ask them to provide a CV just to check that you've got the right person doing the right job, essentially, and check their expertise. And I mentioned earlier that in this instance, it was mentioned that there was a low risk of dissolution, and low risk, of course, doesn't mean no risk. So further inquiries may be necessary. But in respect of consultants, the message is to properly review the data you're using. In this instance, there was data showing that over 5 sites nearby have had instances of ground dissolution. So that should have been raised in the report, and ensure that any risks, no matter how small, are flagged. Because if you don't flag these risks, well, you're going to have claims of negligence levied against you. And ensure, of course, that the individual producing the report and any carrying out a peer review are understanding the purpose for which the report is being produced, and they've got the necessary skills, knowledge and experience in order to know what risks need to be flagged. So moving on to our second case of today, this is BDW and Ardmore, and this is about DPA claims being adjudicated. So to give you some context here, Basingstoke Property Company Limited has engaged Ardmore to design and build an apartment block in Hampshire in 2002, so quite some time back, and PC was achieved in 2004, and Basingstoke assigned its rights and interests under the contract to BDW. So fast forward then to last year in 2024, BDW referred a claim for fire safety defects to adjudication, and it did so on the basis of the DPA. So the adjudicator found that Ardmore was in breach of the contract and its obligations under the DPA, and it awarded a whopping £14 million. The reason why the DPA, the DPA being used in adjudication is significant is because of the extended limitation period, which was introduced under the Building Safety Act, which is why they can look back further than 6 years if it's a contract or 12 years if it's a deed. So it's very significant because this was potentially widening the scope of adjudications or what can be adjudicated. So Ardmore refused to pay that award, and then enforcement proceedings were commenced by BDW. And Ardmore resisted enforcement on well, a number of bases, but most notably lack of jurisdiction, saying the claim was made under the basis of the DPA, which is not within the usual contractual limitation period, and that it's not permissible to bring such claims in adjudications, and that was the conventional wisdom. And secondly, a breach of natural justice, saying it's inherently unfair because of the time that elapsed since the works had taken place. And I've got some sympathy with that, and I'll come on to that shortly. But the court essentially didn't have those submissions, didn't accept them, and enforced the adjudicator's decision. So what are the takeaways here then? I mean, this is massive. It could potentially open the floodgates here to adjudication claims. I will say, though, that the case has been appealed, so the appeal is due to take place next year. So let's see what happens. But claims for historic defects, I mean, there's going to be issues looking back 20 years in getting your evidence together, getting any documents. There's going to be things missing. And as a result of that, I think we're probably going to see potential natural justice arguments and case law in respect of DPA adjudications, given the passage of time. Because I can foresee that there'll be some cases where, there will be fairness arguments that are raised and that are merited. Given that time, I'd suggest be proactive about reviewing older projects. Consider what documents you have and what documents may be missing, and even if no claim is currently being contemplated, then be proactive about trying to get those documents. Considering the 30-year limitation period as imposed by the Building Safety Act. And where any documents are missing, you may want to consider reaching out to other parties involved, as they may be able to assist. But as always, take advice if any issues occur and arise in relation to projects you're involved in or have been involved in. Speak to someone as early as possible. So moving on to my last case today, which I'll canter through because I know we want to get on to the Q&A session. This is the case of Tophausen, and it's all about liability caps. So Rolls-Royce engaged Tophausen to design and maintain a digital visualization software. Following various delays and disputes, Rolls-Royce decided to terminate the agreement. The agreement included a provision that says the total liability of each of the party to the other was limited in the aggregate for all claims, no matter how arising, to the amount of 5 million euros. Elsewhere in the agreement, there was a provision that provided interest was payable and was a substantial remedy, and the sole remedy for interest for a late payment. So the first instance decision here was held that Rolls-Royce was entitled to 8 million euros in termination damages, less the 800,000 that was owing to Tophausen. So the liability cap was applied, meaning that 5 million plus interest was awarded to Rolls-Royce. Tophausen, unhappy with that interpretation, appealed on the basis that the set-off should be applied after the liability cap and not before, and said that the liability referred to the total liability of either party and not a net liability, considering all claims. So they said if the cross claim did not reduce the liability after the cap was applied, then Rolls-Royce could effectively improve its position by wrongfully withholding payments. And the court agreed with that argument and reduced Rolls-Royce damages to 4.2 million, which is 5 million less the 800,000 owing to Tophausen. However, Tophausen also argued that interest should be included in the liability cap, but this argument was rejected on the basis that it's a sole and substantial remedy. Therefore, Rolls-Royce was entitled to interest in addition to that. So a quick canter through then some takeaways. I mean, an overarching point really when drafting agreements is giving careful consideration to these clauses and how they may be interpreted. And particularly when you're looking at liability caps, carefully consider how they will operate. And if you're wanting it to operate in a particular way, make sure the agreement specifically says that. And with respect to interest, I mean, it's an incentive for timely payment. So make sure that if you're intending that to be included within the limitation cap, that the agreement expressly says so. Well, thank you very much, folks. That's all from me. I'll hand back to Stefan now, who will lead the Q&A session. Thank you.
Good stuff. Thanks very much, Stephen. Thank you, speakers. Okay, we have got nearly 10 minutes left for some questions. And we've had some questions coming in, so I will work my way through as many of these as I can. First one on the subject of insolvency. So Patrick, probably one for you off the back of your part of your section. And the question was, what can subcontractors do to protect against insolvency upwards in the supply chain?
Yeah, interesting question, because we were looking at it from the perspective of an employer looking down the supply chain. Obviously, if you're a subcontractor, you cannot you're not going to be taking out parent company guarantees or withholding money. I think the best way you can protect yourself as a subcontractor, there are two practical ways. One is don't let the debt build up excessively. Obviously, the more that happens, the more you're exposed. And that doesn't mean you need to rush off to adjudication as soon as a payment is late. Most contracts will have provisions in them for meetings between directors before escalating to a formal dispute process. And even if there isn't, there's no harm in picking up the phone. So I would be proactive about debt is one piece of advice. And another practical point is spread your risk a bit. If you solely work for one contractor, if you only work for an ISG, then obviously you're much more exposed if there's an insolvency. So I would spread your net a bit. So more practical points, really.
Good stuff. Thanks, Patrick. George, question for you here. I'll give you a moment just to unmute your microphone. And then I'll come to you on this one, which was around the environmental clauses in JCT 24. So question was, how is the new environmental clause in JCT 2024 being treated in amendments, so schedules of amendments and in negotiations?
So it's an interesting one, and to be honest, I haven't seen it come up too much, and that's partly a result of how that clause is drafted. I mean, we say it's a new clause and that it's been brought from the supplemental conditions into the main body of the JCT contract, but it's still worded as if it is still an optional clause, and it operates almost like an optional clause because the wording there is the contractors encouraged to suggest potential improvements that may improve the environmental performance. So there's not really any carrot or stick in that clause. So if you were an employer who is focused on that kind of priority, then you're going to be looking at beefing up some of the provisions of that clause, making those encourages and the mays a bit more forceful in bringing the contractor to make those suggestions. At the same time, what you might do is include a bit more of a structure in there to set out how that recommendation process is going to take place and exactly what evidence is the contractor going to have to provide to evidence the environmental performance improvements that their suggestion is going to result in. But it hasn't come up too much, but I think there's definitely improvements to be made in the clause for the right employer.
Good stuff. Thank you, George. Stephen, I'll come to you next. So question about claims against consultants. And the question is this. So if producing a report which is wrong is not enough to bring a claim, when will a consultant be liable for preparing a negligent report?
Yeah, good question. I mean, the one we looked at, that was, certainly the case there. It was wrong, but the key point to remember is that there are various elements to a claim that a claimant must meet in order to successfully bring it. So the claimant must demonstrate, firstly, that the defendant owes the claimant of duty, so to produce a report with reasonable skill and care, for instance, judged by the standards of a reasonably competent consultant carrying out those services. So that's the duty. Breaching that duty, falling below that standard, and that there's a loss, a quantifiable loss that's been caused by the defendant. And causation is what's really crucial. And if you can't establish that a negligent report is what caused you the loss, your claim will not succeed. So a more obvious example of the case I discussed earlier is a developer's looking to buy some land and commissions a report, but that report doesn't highlight certain things, but the recipient never read the report anyway, just shoved it in a drawer. If the developer then goes on to suffer a loss, it doesn't matter if the report was produced competently or not. It would have had no bearing on the decision to go ahead and purchase that land, because it didn't rely on, it didn't look at the report. So you need to establish all four of those components, and that's 101 really. But breach, duty breach, causation, and loss. But if anyone's looking at you're facing those situations, or you're considering it, do get in touch.
Thank you, Stephen. Patrick, I'll come back to you. A question about forms of security here. So bonds and PCG specifically, which you mentioned. And the question is, what is the difference between them?
Okay, yeah, good question. They do sometimes get confused. They have the same purpose, which is obviously a form of financial protection, but they are slightly different things. So a parent company guarantee, if we took the example of a main contractor, with a PCG, the parent company, or any company in the group, but it's usually the parent because they're the ones with the assets and the money. If the parent gives that guarantee, then they have all the same duties and liabilities that the contracting entity does. So in practice, what does that mean? Well, if the contractor goes bust and the employer has a claim for defects, they can't bring it against the contractor, but they can bring the same claim against the parent. So it's whatever the contractor would have been liable for, the parent would be liable for. So that's fairly straightforward. A bond is slightly different. So a bond is actually effectively a form of insurance. So it's something which has to be purchased. So the cost is normally passed up to the client, and it's like an insurance product. So a bank or an insurer provides a bond which effectively says that if the building contract is breached, and I'll say insolvency because that's what they're really designed to cover, if the contractor goes bust, then the bondsman, the insurer, the bank will pay out 10% of the contract sum. And the reason it's 10% is because that's generally considered to be the extra overcost of bringing in a new contractor to take on somebody else's problem and take on the risk and finish it off. So it pays out, it's limited to 10%, but so they're slightly different things, but ultimately have the same purpose.
Excellent. Thank you, Patrick. Right, I'll see if I can shoehorn in one more question for George and one for Stephen. George, come to you first. In terms of standard form contracts, which would be the best suited to reuse heavy projects? And by that, I think it means, projects where reuse of materials is going to be more pronounced or more of a focus.
Yeah, it's an interesting question, and I'd sort of preface it with saying that really none of the standard form contracts are explicitly dealing with this kind of issue. Ultimately, the key thing is always going to be what's in the specification. Is it clear? Does it set out the standards that are going to be met and the elements of reuse in a project? I think one thing that's definitely going to be of interest is getting comfortable as far as possible with that inherent uncertainty that there is about the performance lifespan, the current status of of recycled materials. So any contract that builds into it a good testing and commissioning process, sign-off process that's going to give you that level of comfort. A good example of that might be something like the IET form of contracts, so the Model Form 1, etc., which is generally used for sort of mechanical and electrical installations. I know there was one project quite close to our office here in Cambridge, which was a deep retrofit, which reused quite a lot of this lighting system. Something like an MF1 contract with that testing and commissioning is going to be really useful for satisfying a client that system is fit for its use.
Very good. Thank you, George. Time for one more then. Stephen, I'll come to you. Question about the DPA, Defective Premises Act, which you talked about. Is being able to adjudicate claims under the Defective Premises Act a positive thing?
Yes, for homeowners, absolutely. Yeah, I mean, it means they'll be able to bring claims that, you know, on the basis of an adjudication that otherwise would have expired, and you know, otherwise they'd have to go through the court process. So it's a very positive thing for them because they've got this, you know, very quick process. However, I mean, the whole premises of the DPA was supposed to be where a claim in contract didn't exist. So it was essentially tortious claims. It was giving homeowners further options, you know, where there was no contractual claim that they could bring. And the legislation that's been introduced, the Construction Act, you know, that hasn't envisaged that DPA would be the centre of adjudication claims, and the BSA also hasn't amended the Construction Act to include DPA claims. So in my view, I think that this case is potentially on shaky legal grounds. That's before you get into, you know, the debate on whether or not it's a good thing. So I wouldn't be surprised if this one's overturned on appeal. So yeah, maybe we won't get too much of a chance to discuss the merits for much longer, but let's see.
Great stuff. Thanks. A case of watch this space then, it sounds like.
Indeed.
Excellent. All right. Well, we've almost managed to keep to time. I'll wrap things up there. Just to say, I hope you found the session this afternoon informative. As I mentioned at the outset, you'll receive a copy of the slides and a link to the recording in the coming days. If you've got any feedback for us on the session, we always love to hear your thoughts on the sessions that we provide. So please take the opportunity to respond to that email if you've got any feedback for us. That's always gratefully received. And then in terms of sort of looking ahead for the rest of this year, and the quarterly dates for the remainder of our webinar program in 2025 have been set. So those will be set out on the email you receive, as well as being advertised through the normal channels through our website, the subscribers we have, and on LinkedIn too. So in the meantime, all that remains for me to say is thank you once again for joining us. Have a good day, and look forward to seeing you next time.